a review of the class that we did on Wednesday, March 22nd, because my Zooms are not going to my Panepto and they're not linking and all those things. So for a few of the courses and a few of the subjects that we've done this semester, I've made a companion YouTube video. So that's what I'm going to do here. On Wednesday of this week, I responded to requests to provide a sample answer for hypothetical. Before I did that, I shared with you some of the current concerns that I have about providing sample answers, and they're really simple. And I had to balance the interest, right? One disadvantage, in my perspective, of a sample answer is oftentimes the sample answer is provided by someone who has a little more experience than the person who's learning the topic. And that can create a huge range of anxieties for the person who's learning the topic if they look at what someone who has more experience than they do would write as a sample answer and then compare that to what they would have written as an answer and recognizing the gap between those, right? That can be very anxiety producing. Another reason why I struggle with providing sample answers is because I know my writing style. I know the spirit of the essence of how I write, and it works well for me. I have had much success with it, but I am not a trained writing professor, right? We have here at Southern a huge, lovely, wonderful department of extremely talented and gifting legal writing professors. And right, if I were to give some of my work to a legal writing professor, they may say, oh my goodness, what is this? So I'm always deliberate to try not to run afoul or to try not to add anything contrary to what you're being told as a main learning module. And the third reason why I hesitate in providing writing samples is I don't want you to mirror my work, right? I want you to create your own process. I want you to create your own steps. I want you to determine what you're going to do first and right, come up with your own process so that it's something that you use while you're here in law school and that you use for the next 50, 90, 150 years of your law practice. It needs to be you. It can't be me or anybody else. Everybody else is taken. There's no other choice for it to be you. The benefit of providing a writing sample is because, as I am, many people just need to see what it is you're trying to do, right? If you can show it to me, oh, then I can put that in context and I know what the form looks like. I know what the outline looks like. I know what the finished product should look like. I know what the right. All of the reasons are all of the advantages of providing a writing sample. So after I finish arm wrestling with myself, here's the writing sample. This writing sample is going to be in response to the second hypothetical that I provided as a writing exercise. It has to do with negligence, but it focuses on duty. The first writing sample that I provided, or the first hypothetical that I provided for a writing exercise, was negligence, but it dealt with causation. This last one dealt with the duty. Seems like more people were writing examples of the duty and wanted to be able to meet one-on-one. And so I thought, here's a great opportunity because for whatever reason, this one has seemed to touch you. This one has seemed to invite more people to write. This one has seemed to invite more people to seek out one-on-ones. And so let's answer the question. Let's start from the beginning. Yes, your final exam will have short hypotheticals. How many? I haven't decided yet, but yes, it will. You will have the opportunity to IRAC those hypotheticals. When it comes to the organization of your responses to those hypotheticals, I want an IRAC. I want an issue, I want a rule statement, I want the analysis, and I want a conclusion statement. I want to be convinced that you know what the dispositive issue is. Because as we've read over this semester, there's lots of issues in almost every case, right? There's lots of competing issues in almost every case. And we've even run into situations to where, well, which one is the issue? Well, it's the dispositive one. Well, which one is the dispositive issue? Well, it's the one who answers the question. Well, which one answers the question? We finally realized, well, let's look at the syllabus as a clue. Right? What is the syllabus saying we're supposed to be covering today as a topic? Then that's what we're going to be looking for in this case, right? And again, that is not a general rule. That is a Washington rule. That's how I draft my syllabi. So you can't, please don't go to another professor and say this is what Washington does, because no other professor is trying to hear that, right? We have our own method of trying to provide the best instructional model possible. And this is just the one that works for me. So in your writing of your essay responses on my summative, also known as final exam, I want IRAC. If you set it up, if you organize it in any other way than an issue rule application, issue rule analysis conclusion, you're going to lose points. Number two, I want an issue statement. I don't want the bullets. I want a full and complete issue statement. You're about to matriculate into your 2.0 year. You're going to be looking at different writing challenges and different writing assignments and different writing styles. Part of what you probably are going to study is appellate litigation. And you're going to notice that that question presented, that issue statement, is written in a certain format. I want an under, does, when format or a whether, when format. Go back in the semester. We've had lots of examples, especially the ones on PowerPoints, where I set up the issue statement and I would either set it up as an under, does, when, or I would set it up as a whether, when, or there are times where I've set it up as both, so that you can see what that actually looks like living and breathing. Respond to the call of the question. How do I answer your questions, Washington? Answer the question that was asked. Not being flippant, not being disrespectful, answer the question that was asked. If the call of the question addresses one of a multi-part doctrine, for instance, if the call of the question of a negligence doctrine is asking about causation, is it okay to begin with a general negligence is establishing that a duty of standard of care exists, that a breach of that duty, that causation being proximate and actual and damages? Can I set it up that way? Because I've learned that I'm supposed to start big and reduce to minimal, I guess, right? The call is about causation. You want to give a general rule, which is what the doctrine of negligence requires. If that's what you need to get your footing, sure, go for it. But don't get lost. The call of the question, at least in this example, is about causation. Okay. 4, responding to the call of the question. If the call of the question addresses one of a multi-part doctrine, for instance, if the call of the question is asking about causation, do you want us to also briefly address duty, briefly address breach, briefly address damages, briefly address defenses? No. I'm asking you specifically for what I want to see. I'm asking that you respond deliberately, specifically, in turn. If I'm asking you about causation, please don't tell me about assumption of the risk, primary, secondary, or implied or expressed, or failure to mitigate and substantial evidence. I'm asking a specific question. Answer that question. Number 5, all responses are to be typed, which probably goes without said because I believe all of the responses are going to be coming through ExamSoft. Please do not use record citations. As I explained in class on Wednesday, if you're not sure what a record citation is, hold on, I'll show you one. I do not expect you to use a record citation. You will learn about record citations in appellate litigation. In this sample answer that I have provided for the hypothetical, I've used record citations because what I'm trying to show you is how to analyze a case. I'm trying to show you that for this piece of the rule, I'm pulling specific facts out of the hypo to satisfy that section of the rule. And in order to do that so that you could track it, I've used record citations. But again, that is being used as a teaching tool, not as an expectation of what I think your responses should look like. Check for grammar, punctuation, sentence completion, sentence construction, proofreading. This This is the final project. This is the thing that you're turning in. You're going to lose points if you're messy about your presentation, about your form, about your grammar, about your syntax, right? Lawyers, we have 2 tools, our words and our hearts. That's it. That's it. So we have to use our words deliberately, intentionally, compassionately. Remember, life and death lives in the tongue. Be careful, be deliberate about your word choice. Processes. What do I mean by process? You and I have talked this entire semester about creating your process, creating your process, creating your process. What I mean by process, what are the turn-by-turn directions of how you analyze? What is the first thing that you do? What is the second thing that you do? What is the third thing that you do? These are things that you should the muscle memory so that no matter what subject it is, no matter what the question is, no matter what professor you're with, no matter what supervising attorney you're assigned to, no matter what judge you're clerking for, you should have a process of how you start and how you finish so that you can execute it every time, because this is the way that you ensure that no matter how quickly your mind works, nothing gets left behind, nothing gets overlooked. What's your process? My process is my process. My process works for me. As a map, I give to you my process. You may come up with something bigger, better, brighter, faster, better. That's amazing if it works for you, but you don't know until you come up with it and until you test it, right? But I'm going to give you my process. My process for a hypothetical, I get it, I read through it once with no annotations, right? Don't mark it, don't touch it, just read it. From beginning to end, every word, no speed reading, no reading the first sentence and the last sentence, no reading down the middle. You read it word for word. And what I call that is capturing the essence of the call of the question, right? I'm just getting my bearings, right? What you're doing is familiarizing yourself with the boundaries and the limits of the question, of the universe of that question. Second read through is usually where I will start to highlight things that I think are important. If in my first read, I've got a good sense of what the issue is, then my second read, I may start to highlight what I think might be elements of the rule that I'm going to use to answer the issue. I might highlight key facts, right? It's my process. You get to decide. You get to decide if issues in yellow, facts are in blue, whatever the colors of the rainbow are. You establish your own process, but you got to have a process. If you have a professor come to you and ask you, what's the first thing that you do as they're trying to help you diagnose if there's an issue with your legal writing and you say, that's a good question, you're not ready, right? You're not ready. So, what's your process? My third read and subsequently reads is where I'm either finalizing my elements, I'm identifying my key facts, I'm starting to create an outline in my mind about how I'm going to put this on paper. How am I going to transfer and transform this intangible data that exists in my brain, right, into a format that on paper doesn't lose anything in translation. That's what I mean by process. First, read it, right? Here's an example of me reading it. Here's the hypo. This is the first read. There's no annotations. It's still clean. I'm reading the question. I'm reading the last sentence as well, right? Talks about the pedestrian, talks about battery, talks about the defendant, talks about negligence. I see, oh, wow, this could be a two-part question, one that's dealing with battery, one that's dealing with negligence, right? Because we teach these subjects, we teach these doctrines, we teach these areas of law as they're siloed, right? Like contracts is contracts and torts is torts and property is property. But in reality, the way that you're going to see them living and breathing in the world is that it's going to be a whole mix mash of stuff, right? And so what you're doing now is building your skill of discernment, building your ability to decipher, right? Pull it apart, see what works, figure out if it needs to go back together. Here's the second read. For this exercise, what I've done as a teaching tool for this exercise is I've highlighted in yellow what I've determined the key facts to be for the issue that I've identified that I'm going to try to solve. So the walking down a city street, I said that's important. It's a city street. It's a public area. It's not cordoned off. It's not a back alley. It's not a private driveway. This means something. It's a city street. Carrying a shoulder bag, right? This is about a gun that's unholstered. So I create in my mind this vision of this, now that I know, loaded gun, now that I know, unholstered, just jiggling, baby. Go ahead, baby. Right? Jiggling around in this bag, right? A thief snatches the bag and runs away. So these are facts that I've decided in my analysis are important. I'm emphasizing my. You might see some other things that may be just as important. Okay, right? This is a teaching example. That's all it is. It's a teaching example. What is all of this stuff in parentheticals in red? What I've done is I've explained to you in these parentheticals after each yellow highlight why I believe that's an important fact. Don't expect you to do that, but I'm trying to help you set up a process. You've identified what you think are key facts based upon the legal question that you have to answer. Why do you think that these are important facts? I wrote them out to give you an idea of why, right? But this is to help you create your process, right? Here we go. Here we go. I highlight in green this potential red herring. The pedestrian sues the defendant for battery, right? Because I've got some things in here where the defendant has jumped on the pedestrian in an effort to reclaim the defendant's stolen bag. And the defendant had an honest belief that the pedestrian was, in fact, the thief, but the defendant made a mistake. Oh my gosh. Are we talking about mistake of fact? Are we talking about mistake of law? Are we talking about reasonable mistakes, unreasonable mistakes? Right? Your mind is popping, your mind is popping, your mind is popping because it identifies, it sees, it recognizes, and it wants to do something. You've got to be still before you run chasing the car, right? Make sure you know which direction you're running in. Don't just jump out there, because you might be halfway through the analysis of whether or not mistake of law, mistake of fact, unreasonable, reasonable mistake is a sufficient defense for an intentional tort. That's not the call of the question. Be very, very, very careful. Now, for me, I've got a lot of stuff going on in my brain all the time. And for you, you probably do too. You've got contracts floating around in there. You've got property floating around in there. You've got legal writing floating around in there. You've got, oh, wow, the first is coming up. I've got rent due. Right. So there's a lot of stuff happening. I do not know, because you have a you have a student rules and regulations, you have an honor code. This would be the second round of summative exams that you've taken. So you know what the rules are. So I'm not going to instruct you to do anything to violate those rules. But what you've got to do, if you don't have the ability to write it, because you don't have the ability to have extra sheets and you don't have the ability to have your phone with the memo pad on it, right? Even if it's just clearing off a space in your brain, focus on what this problem is asking, not on all the problems in the world that you plan to solve one day. What is this problem asking? Not the next problem. What is this problem asking? For me, so I created this workspace where I actually put together my facts, right? So I took my yellow highlights, right? I just took my yellow highlights and I started to laundry list them as facts. Didn't finish them all because, again, this is an example, but this is a factual summary for me, because by reading this factual summary, I get some direction of how I need to write this thought process on paper. And then I write myself another little note. What am I evaluating? Don't get lost. What am I evaluating? Don't get excited. Don't get distracted. What am I evaluating? Look out for that rabbit hole. What am I evaluating? I'm evaluating the defendant's conduct, because that's what I'm looking at when I'm looking at duty. So what's my issue? I love headers. I think headers are great. A header could be as simple as a word with a colon, right? I'm asking you, well, actually, I'm telling you, IRAC headers are required. IRAC headers are required. I want to see your issue. Here's the header. I want to see the rule. Here's the header. I don't want to have to look through 500 lines of 12 point to try to identify your rule because you wrote it as one big paragraph, right? Use the headers. So I wrote it in two ways. I wrote it as a whether when, and I wrote it as a under does when. Whether the owner of a gun who carries the gun lawfully in a shoulder bag on a city street has a duty of care to a thief when steals the shoulder bag containing the gun and is later injured by the gun. I like it. I think it puts it together. You could probably write it 500 different ways, 500 times better. But it works. Under the duty of care element of the negligence doctrine, does a gun owner who transports their loaded, unholstered gun in a shoulder bag down a city street owe a duty of care to a thief when that thief, who is also on that city street, steals the shoulder bag from the owner and is later injured by the gun when it accidentally fires? There's your rule. There's your issue. Here's the rule statement. You've been with me for a semester now. You know, because I've said to you, you know, because I've graded your papers, you know, because we've talked about it, you know, I love a rule statement with a definition, right? I love, because as I've talked to you, some of you this last week, and I said, well, let's just talk about duty of care. what exactly is a duty of care? Either you couldn't or you wouldn't answer that question. That's not everybody. That's not everybody. But there are some at this, we've got 9 classes left. At this juncture, there were some that really couldn't tell me what duty of care was. They know that they need a duty of care. They know that that's the first element in the negligence analysis, but didn't really have their words to explain to me what a duty of care was. So, one good way is to start with a definition. Duty of care. Element The duty of care element is one of 4 elements that must be established by a preponderance of the evidence for a plaintiff to establish a prima facie case claim of an alleged defendant. You see, I said it's one of 4, depending upon how you use causation, and maybe one of 5. I did not go on to list the other 3, or depending upon how you look at causation, the other 4. But I did mention that duty of care is one of several others, right? The call of this question seeks information only about the duty of care element of negligence. Hence, only the duty of care element is going to be addressed. So there it is. I know that there's other elements. I know that this is not a rule of law that's weighted. This is not a rule of law that's balanced. So where you're balancing interest. So the assumption is that each of these elements weighs pretty much the same. There's not one element that's more important than the other, right? You're going to learn more about that as you learn rule structure and appellate litigation. But I want for the reader to know that I know that there's more elements in the negligence doctrine other than duty of care. But I also want the reader to know that I am going to address only the call of the question, right? Very nicely said. The duty of care element of negligence, also described as the duty to uphold a standard of care, has 2 required components. Now, as I worked with this with some students this week, I initially made this 3 components. So, Washington, is it 2 components or is it 3 components? It's kind of like, well, is causation 2 separate things or one thing with just 2 different prongs, right? That is a form over substance matter, and I'm not big on form over substance. If you want to separate this into 3, do it. You want to separate it into 2, do it. You want to make it all one, go for it. But you must be writing with the precision of a surgical instrument so that the rule statement isn't overbroad and clumsy and messy, right? Remember, the rule statement is the nice, neat little package of rule of law that you can apply to the facts in this case and pick same package up and go take it and apply it in another case with similar facts, similar issues. That's your rule. You want to be able to say, boom, I put the rule on the facts, like I dropped a bomb on it. It did this thing. And I now can conclude that this is how this rule works. This is how this rule tested. I'm going to take up my little rule in this little package. I'm going to move it on to the next similar issued, similar fact case. So what were the 2 components? What are the 2 components? What was the 3rd component? And why did I change it? Initially, as I was explaining this to individual students this week, I made this 3 components. 1, an obligation to carry yourself, or if you prefer to use behave yourself, or since we're really talking about the defendant's conduct yourself, right, in a way that avoids unreasonable risk of injury or unreasonable risk of harm to others who are within the zone of foreseeability. Initially this week, it was an obligation to carry, behave, conduct yourself in a way that avoids unreasonable risk of injury or unreasonable risk of harm to others. The second component was an identification of the others. The others are persons within a zone of foreseeability, right? That's right. And then the third thing is that conduct, that behavior gets measured by a reasonable person. That is a general, reasonable person test for the existence of duty of care. That is the general reasonable person standard test for the existence of a duty of care. Why did I emphasize that is a general reasonable person standard to test for duty? Because there's more than one way to establish duty of care, right? Y'all probably learned this from last semester. I know that we had a discussion about it yesterday. People walked out confused. I became nauseous because the idea of lawyers being confused, right? It doesn't fit in my brain well. Lawyers are here to resolve confusion. Lawyers are here to bring resolution to confusion. If a lawyer's confused, right, it's just not a good look. So to alleviate any confusion, let's take a step back. Let's look at what we're doing. Let's be still for a second so that we can be sure-footed about the next steps that we take. Pretend that duty of care and how to establish it comes in two tiers. Tier one is the general reasonable person, right? That's that general, you are to conduct yourself in such a way that it doesn't cause unreasonable harm or unreasonable risk to people within your zone of foreseeability. Who are the zone of foreseeability? Remember, we sang yesterday, it's who are the people in the neighborhood, right? Who are the people with that bubble who could be potential injured people, right? If my conduct is not consistent with the expectation, who are the people who could be potentially hurt? That's my zone of foreseeability. Not to be confused with the foreseeability testing of proximate cause. Two different things. Tier one, general reasonable person standard. Now, we've read 3 cases just within the last 2 weeks that has explained to us that there are times where a general reasonable person standard does not work. It's insufficient, right? And that's why tier 2 are alternatives to the general reasonable person standard. Alternatives. One of the alternatives to the general reasonable person standard is the duty of care that's established through customs and practices. When would I see that? Let's name the 3 cases that we've gone over in the last 2 weeks. Osborne, Irwin Memorial Blood Bank. That's where we had the plaintiff's expert speak about the duty from a general reasonable person standard. And then we had the defendant's expert who spoke from establishing a duty of care by the customs and practices of the profession. What did we learn? When there's a professional involved, the reasonable person standard is insufficient. We need an alternative way to determine the duty of care. We use customs and practices. That was the Osborne v. Irwin Medical Center case. That was the Russo v. Griffin case. And that was the Carbone v. Tierney case. Reasonable person standard wasn't enough. Negligence per se. Everybody jumps on negligence per se. They see that there's a statute and that the guy didn't violate the statute, and they're done analyzing. That's how you get wrong answers, because you jump to the conclusion and you don't go through the process. Show your work, go through the process. You were taught this in last semester. I reminded you of it when we reviewed this in class today. but I'm putting this in this video from Wednesday's class. So all of that information is easily accessible in one place for everyone. In addition, I posted this handout in Canvas. So you have everything that we are doing right now at your fingertips. You can listen to it as many times as you want, look at it as many times as you want. If you have questions about it, you know you're going to get in touch with me. Negligence per se. What is it? Negligence per se is when there's a statute or law, right, that has been established that specifically protects a class of persons for which the potentially injured party is a part of. It is a statute that is intended to protect people that share a common class, right? These people within this class are all persons within the zone of foreseeability. Negligence per se. My daughter was in an accident this weekend. I'm talking to the insurance company and I'm throwing words like I'm throwing hands. I'm throwing words like I'm throwing hands. I'm throwing them so fast they can't catch them, right? Negligence per se, violated several traffic laws, got ticketed, and because of that conduct caused a wreck, right? Do you really want to play with me? I think I need to see the limits of your liability policy. I apologize. I digress, right? The speed limit, one of the laws that he broke, is written so that the people on the street, while you're on the street, are protected. These are the drivers or the pedestrians or whoever has lawful access to the street that you're driving on are potential injury victims if your conduct is not meeting the level established. What's the conduct? The conduct is driving within a certain amount of speed. What happens if you speed? There's a greater possibility that you're going to hurt somebody. Who would be the people that you're hurting? The people on the street with you. The speed limit is created to protect that class of people who may potentially be injured by your bad conduct. There is nothing in the duty of care fact pattern that states, that indicates, that leads one to even in the wildest dreams believe that the statute that allows you to carry a gun unholstered without speaking to the requirement of the gun being loaded or not loaded, right? You can carry a gun if you want to. We're not even going to talk about if you want to carry it loaded. And since we didn't speak to it, right? Plain language, you're going to learn that in appellate litigation. Plain language and statutory interpretation is, I guess I can carry my gun loaded. All I know is I can transport a gun however I want to, as long as it's in good working condition, and it's unholstered. Who is that meant to protect? The gun owner, right? Gives me a greater probability that I'm going to reach my gap before you reach yours, right? I'm going to get to my gun before you get to yours because I don't have to thumble and bumble with a holster. But that surely isn't meant to protect the other people in the neighborhood, right? If I'm walking down a city street with my unholstered loaded gun, the law that says that my gun doesn't have to be holstered ain't protecting the people on the street, because I could fall and that trigger, if it's not set on safety or depending upon what kind of gun it is, right? I'm from Texas. We all get guns for our 8th birthday. So, right, I know a little bit about guns, but that it could go off accidentally and wind up shooting somebody. So I saw negligence per se. I learned last semester that if I see this thing, I'm supposed to follow the thing. Okay, let's say that's true. you see the thing, negligence per se. You follow the thing, negligence per se. Understanding all of negligence per se, not just that there's a law, but understanding all of negligence per se, right? You would analyze and quickly surmise that this law is not written for the benefit of the people who are walking down the street with the person who has the unholstered gun, right? So there is no negligence per se analysis here in that hypothetical, right? So what was the standard test of duty that I jumped over to get to the alternate test, right? I jumped over the general test to get to the alternate test. And the alternate test isn't applicable because this law doesn't meet the necessary requirements for negligence per se. So as far as my analysis is concerned, what am I left with? Left with the general rule of duty of care. So that's where my analysis is going to be. What's another reason that you would know that you're not going to work on negligence per se? Because I didn't teach it this semester. We didn't talk about it this semester. Why do you know that res ipsa is not part of the analysis that you're going to do? Because I didn't teach it this semester and we didn't touch it this semester. We most definitely touched customs and practices. We most definitely spent the lion's share of our time on the reasonable standard of care, right? So if we're going to use it, we don't get to pick and choose what part of what we learned we use. We either use the whole thing or we don't use it at all. Analysis. I've done my issue. I've done my rule, my analysis. What I'm doing in my analysis, I want you to see my process. I set my analysis up by key facts. So what you're going to see is my 3-part rule. Well, I combined it. My 2-part rule. Let's go back to the 2-part rule. An obligation to not cause unreasonable risk, right, to the people within the zone. And then I test it. So what do I do first? I apply the obligation to conduct myself in a way that avoids unreasonable risk to people within the zone of foreseeability. And then what's the second thing that I have to do? The second thing that I have to do is I have to test it. Okay. I set mine up as key facts. So for each of my key facts, I'm going to address component number 1, which is the duty to carry myself in a way that I don't cause unreasonable risk of harm to others within the zone of foreseeability. And then I'm going to apply component number 2. And when I finish with that first key fact, I'm going to go to the next key fact. I'm going to apply component 1. I'm going to apply component 2. What do I do next? I'm going to go to my 3rd key fact. What am I going to do to my 3rd key fact? I'm going to apply component 1. I'm going to apply component 2. Then what am I going to do? I'm going to go to my 4th key fact. What am I going to do when I get to my 4th key fact? Well, that one's a lot easier, right? Because that's the whole negligence per se piece, right? But I'm going to apply component 1 and I'm going to apply component 2. And once I've completed all of that analysis, I should be able to say, based on the aforementioned explanations, ta-da, the defendant had a duty of care. Now, I had a question. Well, instead of setting it up where I'm using key facts, can I set it up where I use elements instead? Absolutely. Well, what does that look like? Well, element number 1, right? Instead of key fact, where I'm applying component 1 of the rule and then component 2 of the rule, this would be element 1, where I'm applying key fact 1, key fact 2, key fact 3, key fact 4, and I come up with a conclusion. Then I would go to element 2, and then what do I have to do? I have to pull the facts. See my record citations. I did that again as a teaching point. Wanted you to be able to see that we are literally pulling facts from the hypothetical and using that to support the prongs of the rule that have to be established. And I do that for all the times that I need to do it, right? That will ultimately get me to a therefore. That is a legal analysis. That is one of many processes. That's the, let's say we're using Waze, and let's say we're using Yahoo Maps, and let's say we're using Google Maps, and yeah, right? It's all going to get me to the same place, but it might take me 3 different directions, right? I just gave you the Washington Highway. I just gave you the Waze maps using the Washington Highway. You might want to use the Google map using I-10, or you might want to use the Yahoo map using I-12, but you're ultimately trying to get to the same place, which is this conclusion. But that's my process, my turn-by-turn direction. My step 1, I read it once for context. Step 2, I read it for the issue. Step 3, I start to identify the key facts. Step 4, if the rule is in there, I'm going to identify the rule and the elements. Or it might be a rule that I'm expected to know, right? I'm going to then, I guess, step 5 or 6, I'm going to write my issue statement as an under does when, or my issue statement as a whether when. Step 7, or whatever the next step is, I'm going to write out my rule statement. Step 8, I'm going to do my analysis. Step 9, I'm going to do my conclusion. And that's the way that I'm going to fire every time I get asked to do a legal analysis. I'm going to take those 9 steps. I'm going to take those 9 steps, and I never miss a thing. I never miss a thing. What is your process, right? The must, M-U-S-T-S, the must, because I'm telling you, you don't have to go down my highway. Maybe the tolls on my highway are too much and you don't think it's worth it and it doesn't get you there fast enough. That's great. What are the must? The must are page 1 and 2. Has to be in an IRAC form. Has to be under does when, whether when as to the issue. I need you to respond to the call of the question. Don't give me everything under the sink, right? Bar question, everything under the sink, throw it all, right? Essay question, I'm one professor, 78 of you. It's a 3-hour test. I have, feels like just hours, but it's a few days to get all of this stuff graded, to get all of that stuff back to the administration so that you can get the information that you get, which is all perfect. But what I'm saying that to say that I have a limited turnaround time, right? I'm not the bar exam where I can hire 500 readers and they can give each response 2 minutes. And then in the course of a couple of days, grade thousands of essay responses, right? I don't have that kind of machine in place. It's me doing all of this, trying to do it with integrity, trying to do it with grace and compassion, and trying to do it efficiently so that all the grades can be calculated, so all the information gets to where it needs to go, so that all of that information gets to you, right? So that is what we covered on Wednesday, March 22nd. That is a sample answer to the Judy hypothetical. If you have any questions, please, we have 9 meetings left. We only have 9 meetings left. You know how to reach me 24 hours a day, 7 days a week. You know how to text me. You know how to email me. You know how to phone me. If there's anything that I can do to make this clearer or clear out any, I hate to even say the word, confusion that I may have created. Because if you end this video and you are unclear, it is my responsibility to explain this until you are firm in your confidence that you understand what's being asked, right? That's my responsibility. But I don't know to do that unless you accept your accountability and let me know that something's missing, right? Let me know that your brain's not on fire. Let me know that it's not popping. And let's sit down, and however long it takes, whatever day that is, Saturday, Sunday, Monday, Tuesday, Wednesday, Friday. I'm sorry, I digress. Let's have a conversation. Let's map it out. Let's talk it out. Let's work it out. I need for you to be successful. The world is waiting for you. If you have any questions, please reach out to me. Thank you for the opportunity to serve.